Hi, this is P.R. Krishnan. Welcome to this sixth edition of the RERA My Perspective. In this video, we'll look at compensation, what it is, how you can get it, when, etc. Let's go straight to the topic, as this is a little longer video. We need more time for this. Okay. While discussing compensation, we shall also discuss the section 12, 14, 18 and 19 in a little more detail, as these sections are very important from consumer perspective and an understanding is a must. Section 12. We have seen this in the last video also. What is section 12? We'll again discuss it in much detail now. Where any person makes an advance or a deposit, if you are making an advance or a deposit, on what basis? Basis the information contained in the notice or advertisement or prospectus. This is an advertisement. In whatever form of advertisement, or on the basis of a model apartment or a sample flat, plot or building, whatever case maybe, and sustains any loss or damage by reason of any incorrect, false statement included then, and therefore basis on that discussion you book an apartment, you give an advance and you sustain a loss. The loss is he shall be compensated by the promoter in the manner as provided in that. You have to be compensated. So you are delayed upon his advertisement, they have made a false advertisement which is incorrect, section 12, and therefore you need to be compensated, provided that if the person affected by such incorrect false statement contained in the notice, advertisement or prospectus or the model apartment, plot or building, or notice, etc., which we saw, as the case may be, intends to withdraw from the proposed project, he shall be returned his entire investment along with interest at such rate as may be prescribed, and the compensation in the manner provided under this act. Which means basically, if because of these reasons of false showcase of flat, model apartment or advertisement notice, etc., and you are booked and then it turns out to be a false statement, and if you are wanting to continue, it is okay, but if you are wanting to withdraw, come out of the project, if you want to come out of the project, then you shall get back the entire investment along with interest at such rates as prescribed therein. Compensation will also be provided in the manner outlined in the act. Obligation pertaining to veracity of advertisement, where builder gives wrong or false information or correct advertisement or statement and take money from public, they should refund investment plus interest plus compensation. This is very clearly given. No builder can give a wrong advertisement or showing off too much but actually not going to give. We have seen that many cases, right? So that should be a wrong advertisement, false advertisement, false propagation, notice or pamphlets or audiovisual or anything you call it. Everything is covered in some way that you are giving something information, whether it is a written paper, newspaper, hoardings, whatever, or sample flat, but you are giving something else, not acceptable. Okay, that is section 12. Section 14, adherence to sanction plans and project specification. Suppose you have the builder has shown you some plan which he has received. Okay, he has to adhere to that plan. Once he signs with you, he has to adhere to that plan. This is what this section completely says. Builder should develop and complete as per plan. For any change, he needs your written instruction for a change in the flat. Minor changes are okay, but any change outside your flat for the project, he needs 2/3 clearances in writing of the allottees. This is also to do with illegal construction. You can claim compensation if there is some change required, as it is not selling. The builder has to take written clearance. Suppose the building is not selling, and then you can take written clearance from you from 2/3 of the allottees and change the plan. So if it is in a different tower, then required from the tower members only. If he is making 4 towers and 4 are different societies, wherever he is going to make the change, only from that tower, basically that is a project. From that project, he has to get the written sanction of 2/3 of the members from that tower. Section 14(3). In case any structural defect or any other defect in workmanship, quality or provision or services or any other obligation of the promoter as per the agreement for sale relating to such development is brought to the notice of promoter within a period of 5 years. In short, any structural defect or workmanship defect or quality, etc., which is brought to the notice of the promoter within a period of 5 years by the allottee from the date of handing over possession. It shall be the duty of the promoter to rectify such defects without further change. Within 30 days he has to rectify, and in the event of promoter's failures to rectify such defects within such time, the aggrieved allottee shall be entitled to receive appropriate compensation in the manner as provided under this Act. Okay. If he doesn't do that, then you can ask for compensation. Within 30 days he has to correct the defect, whatever defect or changes that are done. Let us go to the third important factor. So once first 12 we saw, it is basically false advertisements, whether in terms of showing false sample flats or anything, or in terms of brochures or advertisements or hoardings or whatever. Section 14 we saw it was change in the plan. He has to take a written confirmation. If it is outside your flat, then he has to take the confirmation from 2/3 members. Now let us look at section 18, delay. Where one is not giving possession on time, he can claim refund with interest and compensation under this also. Under this clause also, there is one subsection which calls to say that he is supposed to take insurance also for any title defects. In accordance with the terms of the agreement or sale, or as the case may be, duly completed by the date specified therein. Okay. If the promoter fails to give possession, or due to discontinuance of his business as a developer, or on account of suspension, if he's got suspension revocation or registration revocation, then also in these two cases he shall be liable on demand to the allottees in case the allottee wishes to withdraw from the project without prejudice to any other remedy available to refund the entire amount, including such rate of interest at such rates as may be prescribed in this behalf, including compensation. Okay. Section 18(2) says the promoter shall also compensate allottees in case of any loss caused by him due to defective title. If the title is defective, he is responsible for its life, the entire life. Okay. So even after 20-25 years, you can always claim compensation by way of full refund, interest, etc., and compensation if there is a title default. Section 19 deals with rights and duties of allottees, which we will see at a later time. Section 18(3). The promoter fails to discharge any other obligation imposed on him under the Act or the rules or the regulation made therein, or in accordance with the terms and conditions of the agreement for sale, he shall be liable to pay such compensation to the allottees in the manner as provided under that. So these three you have seen basically 12, 14 and 18. If there is any other clause under which he needs to be, he is defaulted and which affects the allottees directly, he needs to compensate. Section 19, which we are just seeing, it is the right of allottees to get information. You can get information. You should get information, plans, layout, stage-wise schedule of completion. What water, electricity you will get, when will you get possession, what are the common areas. When you are making the AOPs, claim refunds, interest. If there is anything like this and he is not giving, you can claim interest and refunds. Similarly, section 19 also says that if allottee delays, you need to make the payment to the builder in the same rate of interest as applicable to the builder. 40. If a promoter or an allottee of a real estate, as the case may be, fails to pay any interest or penalty or compensation imposed on him by the adjudicating officer or the regulatory authority or the appellate authority, as the case may be. Now, if a promoter is a builder, fails to pay any interest or the compensation or the refund which has been imposed by the adjudicating officer or the district judge or the authority, okay, or anybody under these rules, it shall be recoverable from such promoter or allottee or real estate agent in such manner as may be prescribed as an areas of land revenue. So the matter will become something different. It will get into the land revenue and his land and everything can be taken over. Okay, so that's a very important clause, compensation and how you can get it. There is another section under 40 which says if an adjudicating officer or regulatory authority of the appellate tribunal, as the case may be, issues an order or directs a person to do any act or refrain from doing, you can say you can you should not do that, or maybe that amenity you should not change it or something like that. Okay, or the rules thereunder made thereunder, and then in case of failure by such person, if the person fails or defaults or fails to comply such order or direction, then the same shall also be enforced in such manner as may be prescribed. Section 71 and 72 we have just seen in the last video also. Section 71 talks about the power of to adjudicate, who can adjudicate. We have seen under interest and in the earlier slides also what circumstances the AO decides and adjudicates, that we went in detail the last video. The power to adjudicate interest as a compensation flows from this section. It is a long section, but to put it simply, this section states about appointment of a judicial officer who is a district judge or equivalent. The judge to adjudge compensation under section 12, that is false advertisement, 14 changing plans, 18 section 18 delays, and 19 of course allotted default also. Dispose of case within 60 days, there is a time limit. Can summon anyone and force his presence to give evidence. Section 72, it talks what are the factors the adjudicating officer takes while determining this compensation. The amount of disproportionate gain or unfair advantage were quantifiable, made as a result of the default. The amount of loss caused as a result of the default. So one is wherever is possibly trying to quantify the loss. Second is what is the disproportionate gain the builder has got out of this. The third is the repetitive nature of the default. Is the builder repeatedly doing that? And such other factors which the adjudicating officer considers necessary to the case in furtherance of the justice. Compensation is another method of cost, difference in cost when booked. See the compensation, how different people earlier it was being looked at is, suppose you book a flat at let's say 40,000 rupees per square feet now, and after 2 years he delayed or change in plan or whatever, where you want to come out, then the same place the rate today is 42,000. Then earlier it was practice that they should give 2,000 rupees per square feet, because that is a compensation. He has to get the same flat. But nowadays what is happening is, earlier also then or a lot of debate whatever it is, you can get a maximum compensation of say 5 lakhs. The average is 1 or 2 lakhs or 3 lakhs. That's the compensation they give. However, in reality this is not decided like this. As I told you, they give it only up to 2 to 5 lakhs maximum. If you have a lot of mental harassment and a lot of time spent, then probably 3-4 lakhs or 5 lakhs. 5 lakhs is the maximum. Now if you are paying an EMI, then interest is supposed to be equivalent to that interest. You have EMI basically you are paying. Then compensation will be the rent that you are supposed to pay. Again, suppose you are paying an EMI and you are staying on rent, so interest will equal to the supposed to be equal to the EMI, and rent is supposed to be the compensation. But that again was debatable, etc. So, however, while implementing the law, it was finally decided to provide interest at the SBI MCLR rate, okay, and that is plus 2% more on that. State Bank of India marginal cost of lending rate, whatever the rate is on that day, they will add 2% to that. Has been decided. So that is the interest rate. Compensation, of course, depends. It's very subjective. So in the process, when real estate rates were rising, the buyer becomes a loser. So what happens? You are only getting SBI rate and hardly much compensation. When the real estate rates were going up from let's say 10 to 15,000 rupees, the builder is benefited, but you are at a loss, because now you have to book a new flat at 15,000, not at 10,000, and you don't get that interest or the compensation. To that extent, the buyer, seller, the developer can cancel the agreement and take it at a higher rate, new rate. He gets more money. Okay. Similarly, if the interest rate is based on judgment rate, the rate of interest is constantly falling, and hence here again after 4 years, the buyer gets prevailing rate of 3% to or plus 2%, let's say 5%. Whereas if he has invested, the interest rate would have been 8%. Suppose you have invested in 2015, the interest rate would have normally then be fixed deposit would be 8% or 9%. But as the case goes on, after 3-4 years, then you make a complaint, and again 2 years the case goes on. So 6 years later, the NCLR has come down to 4% or 6%. So at best you get is 6 plus to 8%, whereas you would have got 9% or 10% earlier. So there you are a loser. That is how it works, friends. This is a little longish video, so I'll close it today. Okay, let me bring back the screen. Yeah, screen is back. We have covered very important areas of compensation and details under of section 12, 14, 18 and 19. All are very important for you to remember. This and the last video both are equally important, because last video we covered compensation offenses and penalties, etc. So that's all important and part of this. With this we have covered the claim part. In the next video we shall discuss adherence to sanctioned plans, title defect, offenses and penalties. This is yet another important section that brought the developers to some discipline, because they were not adhering to the plan. So it's all very important. Offenses are very important, so you can understand what the offenses are. So it is important to know. So far we have covered the background, objectives, landmarks of the new legislation, the main features, various important definitions, process of registration by builders and their importance, interest in great detail, compensation, adjudication, and now compensation and its process. So please do keep watching the videos, and before I leave, if you have liked the video, please subscribe by clicking on the subscribe button and leave a comment, which will be very useful. Please share this with other groups so they also get the benefit of this knowledge. Thank you.